Critics of the Constitution say that the Constitutional Court has failed to realize the aspirations and dreams of our people. Courts are reactive. We deal with what comes to us. We can't go and get cases in the street ourselves. The courts are under tremendous strain. There are not enough judges, there are not enough courtrooms, there are not basic resources, tools of trade like laptops, desktops, even recording facilities, and posts are being cut back all the time in all courts. I experienced apartheid firsthand, not only in my career but also like all of us personally. It will increasingly start grappling with more complex issues like artificial intelligence. We're going to start battling with cryptocurrency issues. We're going to start grappling with cybercrime issues.
Justice Majiedt, thank you so much for sitting down with us.
Sure.
I'm really excited in particular to sit with you because we are reflecting on 30 years of the court, 30 years of democracy. And you were there since the beginning. You assisted with the first democratic elections. So we're really looking forward to hearing your thoughts and your insights on how the court has evolved over the past 30 years. And with that, here's the first question. So you've been a judge for over 2 decades and a practicing advocate prior to that. What are your views on the role and significance of the court, and particularly how this court, the Constitutional Court, has evolved?
Thank you for the opportunity and good morning. I started practicing in Cape Town in 1984, and the courts looked very different then. We lived under parliamentary sovereignty. Apartheid was very much the order of the day, and courts were a battleground for almost everything, not only for public interest matters and human rights matters, but every case became a battleground. This has changed tremendously with the advent of the Constitution. Our courts have not only become more inclusive and more human rights oriented, obviously, but also more humane. People are treated with dignity and by and large equally, and that was not the case under apartheid courts. People were treated differently, not only in terms of their race and color, but also in terms of gender and class. And so more affluent people were treated with more respect in the courts than those who were not. And of course, black people, and that's black generically, were treated very differently from white people, be they witnesses or accused or litigants. And so the courts have changed tremendously. I've seen the changes, and it is a very positive experience to have seen that change. I think also courts have tended to be more cognizant of their role in public life. Courts have become more cognizant of the fact that the judiciary, and there I include the magistrate as well, it's really the third arm of government. And so it's important that if we want the Constitution to become a living document, that the courts, and those are magistrates' courts, lower courts and higher courts, should treat human beings as the Constitution demands, should dispense justice as the Constitution demands, and overall generally act as we should in a new democratic dispensation.
Thank you for that. I like how you mention, turning the Constitution into a living document. And I think one area where there's been much debate about the Constitution being a living document is the area of socio-economic rights.
Yes.
Now, I must say, as a socio-economic rights enthusiast myself, I have really enjoyed reading your judgments on this particular subject. And I want to hear your thoughts on, how the jurisprudence of the Constitutional Court has adapted to address emerging social, economic, and political challenges facing South Africa over the past 30 years.
That is also one of my favorite subjects, because it's a very difficult area of law, particularly of human rights law, constitutional law. I'm going to start the answer by just digressing slightly to lead up to my answer. I was appointed as an honorary professor of law at my alma mater in Cape Town, the University of the Western Cape. And so 3 years ago, I gave an inaugural lecture. And I can't remember the exact theme, but it was paraphrased. It was a question whether the Constitution has fulfilled the dreams and aspirations of people as far as socio-economic rights concerned? Or is it what I called a dream deferred? That was the topic. And now I'm answering the question, and there I made the following submissions. I said that when you read the Constitution in respect of socio-economic rights, it's imperative to understand that most socio-economic rights, not all of them, are to be attained or realized progressively within reasonable means. And I made the point that just as from an ordinary law interpretation of statute point of view, that you must have regard to the language. And I made the point that the lawgiver plainly chose the language very carefully, realizing that to overcome decades of apartheid and centuries of colonialism and oppression is going to take a long time. And the new democratic government would need time within the available resources to achieve that. And so that's the first point I made. The second point I made, I then turned to the jurisprudence of the earlier court. I looked at Grootboom, I looked at Subramani, and so on. And the point I made there was the court took a conservative approach. That is plainly due to the language, A, but also B, realizing the constraints on government and realizing the importance of the separation of powers doctrine. And so instead of saying that government has to give Mrs. Irene Grootboom a house, it asked for government's housing policy, the Western Cape government's emergency housing policy. And the court examined the policy, decided that the policy was inadequate, sent them back to the drawing board. The same with Mr. Subramani. Instead of saying that Mr. Subramani should get the dialysis he needs for this life-threatening kidney disease he had, court looked at the bigger picture and said, instead of giving Mr. Subramani his dialysis, must look at the needs of other sufferers of kidney ailments that would gain from getting dialysis as broadly as possible.
Yes.
And so, Mr. Subramani died without getting what he asked for, and Mrs. Grootboom died without getting her house. Now, many critics of the Constitution say that the Constitutional Court has failed to realize the aspirations and the dreams of our people. That is only partly true, and there's a reason for why it's partly true, is because the court acted conservatively. The court was embarking on what it knew was going to be a long journey to achieve the realization of socio-economic rights. And so we have moved on, and I want to mention Tubakale, which is a case that is very close to my heart. And when you read that case, you will realize that these people in 1996 already received housing subsidies. They've been sent from pillar to post. The houses were never delivered to them because of just plain corruption within the housing department and also with administrative incompetence. And so they went to court, they went to the High Court, they got an order, they went to the Supreme Court of Appeal, they got an order. And then nothing happened, and they went back to the High Court seeking constitutional damages now, because they said that was the only remedy that is available to them that would be an effective remedy in terms of the Constitution. And the court turned them down and said they didn't make out a case for it. Of course, they came here on direct appeal, and we accepted the direct appeal. And I was in the minority, and in my minority judgment, I examined the language of the Constitution, the same points I made earlier. Yeah. I examined our earlier jurisprudence, Grootboom, Subramani, and other cases. And I made the point that since then the court must examine what has happened since Grootboom, specifically as far as the right to housing is concerned. And I've said that now what has happened is that we have a Housing Act and we have a housing code promulgated under that act. And so there has been movement. We've got to assess whether the movement is adequate in terms of what the Constitution requires government constitutionally to do. And I said that we have moved past Grootboom now. We must now assess, which is all the court can do, whether there has been progressive realization of the Tubakale and others, those residences' rights, and whether there have been reasonable means to attain them. And I found that government has failed in its constitutional duties and its obligations. And I examined the possible alternative remedies, and I found that the only effective remedy really was the constitutional damages to be awarded, coupled with perhaps a supervisory interdict to get them to come, to get the municipality to keep coming back to court every 3 months or so to report. But in the end, because I was in the minority, that was never developed. But I think Tubakale was a step further. Although I was in the minority, I felt strongly that we should now get our socio-economic rights jurisprudence to move beyond Grootboom and other cases, but specifically Grootboom in the context of the right to housing, and move on and to assess where we are and where we should have been. And that brings to the fore the question then. Now, I must just interrupt myself briefly to say there are other cases now pending in this court, which have been heard but where judgments are pending, which will deal with this question as well. The case of Adonisi from the Western Cape.
Yes.
That case will deals with spatial injustice that I also touched on in Tubakale in my minority judgment, and it will deal with the question of the inner city and emergency housing within the inner city, specifically within Cape Town. So that will be another stop on the or a point in the journey towards realization of the right to housing. So what I think socio-economic rights, just to conclude with an overview as to where I think the future should lead us. There will come a point where the court has to say, whether it be the right to health, the right to education, or the right to housing, to examine what the Constitution demands of government to do, to see what government has in fact done,
Yes.
and to assess whether it's done enough, and to say to government, as part of that interrogation of whether it's done enough, is to say, show us your plans, but now you've got to show us what you've done over the last 30 years. And the court can then make an assessment whether this is adequate. Court can't rewrite the housing plan, it can't rewrite the education budget.
Yes.
That's not our function. That will be straying into another lane, and it will be an infringement of the separation of powers doctrine.
Yes.
But the court can also say, well, here was your budget, for example, of the last financial year. And that budget was squandered either because of theft or corruption or mismanagement. And the court must be able to be in a position to say, you got to do better than this. You got to actually reallocate funds for this particular resident or group of residents, this particular school, this particular education region, and so on and so on. So we must always keep on moving, because progressive means exactly that. The court must always ensure, as the ultimate guardian of the Constitution, and this court in particular, that government does what it is supposed constitutionally to do, which is to see to the progressive realization of socio-economic rights, and to show the government must be able to show what it has done within reasonable means, because we understand there are a lot of pressures on the fiscus. There are a lot of demands for the cake to be sliced. But it can't just be a carte blanche. It must be a position where the court actively says, show us what you've done, and interrogate what they say they have done. So that's where I see socio-economic rights, and I think that is going to be a continued area of contestation, especially in this court, but in all courts, the High Court and the Supreme Court of Appeal, and especially this court. Because people increasingly, with the help of very able and competent NGOs, are increasingly saying they want their rights in the Constitution, and they are tired of waiting for their rights. And government can't keep on saying, well, there's no money, or we have done what we could. Courts got to interrogate that. It's got to be more proactive as we move on, because 30 years down the line, we should have seen much movement. And I think, judging from Tubakale, we haven't seen much movement.
Absolutely.
Thank you.
Judge, I just want to take you back. Like I said, I love this topic, and I'm a big fan of how the court has been progressively developing the structural interdict in particular. We saw that in
Yes,
Mwelase,
yes,
how the court is developing supervisory
yes,
jurisdiction to kind of form a dialogue with other branches. So you said in the beginning that, with the court's earlier jurisprudence, like Grootboom, the court was more conservative in its approach.
yeah,
And lately, when we see judgments like Mwelase, there are criticisms that the court is becoming a judicially active court,
yes,
allegations of judicial
yes,
activism. Is
yes,
this, so tying that back to the first question, can we say the court has evolved from being a conservative court to judicial activism?
yeah. I must perhaps just say that I use the word conservative, but perhaps should more use the word pragmatic. It's very pragmatic. But the court has certainly evolved, and you've mentioned Mwelase. I think Tubachale, if any reader would read that, would say, compared to Grootboom, there has been some evolving, there has been some movement. And I always say to people, and I said so in my inaugural lecture as well, that people criticize the court for being too slow, and now people criticize the court for being too fast, in other words, infringing. So we always used to say when I was a judge in the trial courts, if people settle a case, let's say a civil matter gets settled, and if both parties are unhappy, it's a good settlement. That's a good settlement. And so if both sides criticize us, I think that the court is more or less in the right direction. What I then did in my lecture, just to come back to that at the University of the Western Cape, I then said as I concluded, this is a very important topic. It's also an evolving topic. It's a topic with different viewpoints. I addressed in particular there the question of the minimum core concept.
Yes.
And there I said that in Grootboom and Mazibuko in particular, the court specifically disavowed the minimum core rights concept.
And it's been criticized for that.
It's been vehemently criticized for that because the court said it's too vague and ill-defined and so on and so on. And I said, so what I will do to stimulate debate, I then arranged at UWC a number of, two further seminars where I had proponents from the other side, from minimum core rights proponents, like Professor Burchitz of SciFac and Professor Sandy Liebenberg of Stellenbosch speak to minimum core rights. And they held a completely opposite view, and they criticized Mazibuko and Grootboom for not adopting minimum core rights. And then in the end, I had my retired colleague, Justice Johan Vroneman, speak, just to conclude the whole lecture series, and Nomzamo Zondo, who is with SERI, Socio-Economic Rights Institute, from an NGO perspective, about this topic and where we are going and where we should be going. And in the end, it seemed to me that if you call it minimum core or something else, it's more pedantic and nomenclature and verbiage than anything else. In the end, when we say that government must do progressively realize and at least do certain things, you are basically saying there's a minimum core of what you must do. Whether you call it minimum core rights or not, I think it's just verbiage. But in the end, I think the court has evolved. The jurisprudence must keep evolving, because it's not a sprint, this realization of socio-economic rights. It's a marathon, and always have to be done within the confines of separation of powers, and with the courts being mindful of the huge pressures there is on a government that must correct the wrongs of decades of apartheid and centuries of colonialism that really dehumanized people, calculatedly deprived them of their rights. So it's a long journey, but I think the court is progressing. Some may say too slowly, but we are careful. The jurisprudence must evolve incrementally. And we can only decide the cases that's before us. And while I'm at that point, I think it's very unfair and it's totally wrong to blame the Constitution for people not having houses, for people not having access to healthcare, for hospitals looking like what Helen Joseph Hospital looked like that we saw shockingly in the media. A constitution is an inanimate object. It's got the aspirations and the dreams of people. It's a social compact that the people have concluded. And so this is what we would like our country to look like. But it takes people, it takes government, with all its institutions, executive, legislature, and the bureaucracy to implement that constitution. Constitution can't implement itself. So constitution is not per se a panacea to all the ills of society. It is a vehicle to address those ills, but it needs people to use that vehicle to address those problems. And so I think it's very unfair for people to call for the constitution to be abolished, to be skeptical and even cynical about the constitution, to talk about having been sold out at CODESA and at the negotiations. They must look for the problem where the problem really is, and it's not the constitution. I think it's very important that we understand that.
Absolutely. So we've mentioned a number of cases, and I could go on about socio-economic rights, but just out of curiosity, we've talked about Masibuko and Grootboom and Tubagale. What other landmark judgments to you would you consider as the specific cases that have maybe contributed to shaping our democracy? It doesn't have to be socio-economic rights.
Yeah, well, there's a variety. There are the election cases that early on come, and others that establish civil and civil political rights firmly. But there are also other important cases, like the earliest one for me is Makonywane. The death penalty was always for those of us who practiced law under apartheid in the criminal courts. Whether you defended common criminals who got the death penalty, or whether you defended combatants from APLA and from MK and from the BC movements, it was very hard for us when our clients got the death penalty. And I'm a firm believer that the death penalty is not only inhumane and degrading, but it's not an effective sentence. I mean, I looked at many years ago at statistics from the USA that found around about the middle to late 1980s, DNA evidence became available in the US. And a large number of people, I think 60 or 70% of people who had been languishing on death row, where DNA evidence had become available, had to be retried and acquitted. And they escaped the injection or the gas chamber, whatever it may have been, simply on the basis of DNA evidence. So it is irreversible. Once you've hanged somebody, or you've gassed them to death, or you've given them the lethal injection, there's no coming back. It also doesn't reduce crime, and that's statistics from the US, which I thought was very objective at the time I read it, showed that it's not deterrent, it's not an effective deterrent. And so Makonyane was an important case in the death penalty to say that human life matters, state shouldn't kill. And the fact that all 11 judges, for the first and only time thus far that I'm aware of, wrote, shows how important it was, not only for our jurisprudence, but for South Africa's psyche as a new young nation, to say that no more will the state kill through the death penalty. And then pharmaceutical manufacturers was an important case. And there are many, many others. I think recently, and I know it's a controversial case, but there are two cases that I must mention that have evoked the ire of some, in one case more than the other. And those are I'll just call it the Commission into State Capture case, where we sent the former president to jail. And the other one is the Walus case. Now, in both those cases, the court was under tremendous public pressure for different reasons. But the first judgment, the Zuma judgment, shows that all are equal before the law, and the court must reaffirm the supremacy of the Constitution. More importantly and more particularly, the rule of law. Law must rule, otherwise we fall into anarchy. And whether you're a street sweeper or the former president of the country, you must comply with the law. If we allow people with money, class and status to undermine the rule of law, we can just as well shut up shop and tear up the Constitution.
Absolutely.
So in that instance, that was a very important judgment. And the court had to stand firm in the face of tremendous public, from certain quarters, public outrage. And of course, the court was afterwards blamed for what had happened in KZN and Gauteng, the riots, which I thought was grossly unfair. But that's a subjective opinion. Walus was a different kind of pressure. I mean, all of us rational, right-thinking people in this country had great admiration for Mr. Hani. I met him personally and I thought he was a wonderful, humble man. who would have been an excellent leader in this country. And when he got assassinated, we were on the brink of civil war. And so here comes a man who had pulled the trigger, and your immediate reaction is, well, this is the man who almost plunged this country into civil war. And yet you've got to apply the law. And the court unanimously in that case, in the judgment written by the Chief Justice, former Chief Justice Zondo, made the point very clear that regardless of who you are, whether you are the man that brought us on the brink of civil war, the callous act of assassinating one of our most beloved leaders, or whether somebody else, we must apply the law and you must get the benefit of the law. Now, if you read that judgment, he simply carefully applies the Correctional Services Act as it read then, as it reads now. And he said, if you read all of that, then what Parliament has enacted, not what the courts have said, what Parliament has enacted, shows that this man should have been released or should have been considered and released on parole if he qualified. Long ago, because I must make the point, on the common cause facts, there was no dispute that Mr. Wallace was fully rehabilitated, that he'd followed all the programs in prison that he had to, and that he'd complied, he was a proper candidate for parole. And so all things considered, if you apply the law and you have a candidate who is fit to be released on parole, then the court said, we can't send it back to a minister, and the minister will take the same decision, and this revolving door, many times before. Because it was a very hard case, I think, and the court grasped the nettle, and we ordered that Mr. Wallace be released on parole. It didn't go down well, particularly with his closest family, but also with many of his supporters, particularly in the Communist Party, and I've got full understanding for that. But a court, however difficult it may be, must apply the law, and must that law, the benefits of that law, as they may be, must redound to everybody, even to a villain as we would maybe regard him as Mr. Wallace.
And that goes back to the language of rights that you spoke about, the language of the legislation as you spoke about. Yeah.
Exactly. The law must rule. Law must rule. Otherwise, the Constitution will become worthless.
I'm so glad you brought up those last two cases, because we were going to ask a question about, how the court has been increasingly called upon to deal with politically loaded cases.
Yes.
And I'm just wondering, based on what you mentioned now, what are the implications of this in a democracy such as ours? Do you think maybe the public is slowly losing faith in the court because of the number of politically loaded cases that it has to deal with?
Yeah, well, that is a very difficult situation. And courts are reactive. We deal with what comes to us. We can't go and get cases in the street ourselves and hear them. So in a sense, it is regrettable that so many political skirmishes which should be sorted out amongst the politicians themselves end up in the courts. And we've seen that, especially the Pretoria High Court, but also the Cape Town High Court, because Parliament is in Cape Town and the executive is seated in Pretoria, have had to deal with the brunt of those cases. It's unfortunate, but I think courts must do what they must do. If the case is before you, must decide it. And when we decide cases, it's the same for all cases. Whether you're a motor vehicle collision or a contractual claim, any case, or a constitutional rights claim, there'll be one party that loses, and that will be the dissatisfied party. And so whichever judgments we give in these politically charged cases, there will always be an element of society that's unhappy. That comes with the territory. It's an occupational hazard. It's being sitting in court as a judge. You must deal with that. But I can't say whether the public is losing faith in courts because of that. If it is so, it will be most unfortunate, because it's not the court's fault. It's really because of those who bring the cases to the courts. The courts are under tremendous strain. There are not enough judges. There are not enough courtrooms. There are not basic resources, tools of trade like laptops, desktops, even recording facilities, and posts are being cut back all the time in all courts. Even a court as this one, the Apex Court, is being told continuously that we can't replace essential tools of trade because there's no money. And so courts are under tremendous strain, and the cases are coming more and more, ordinary cases, but also constitutionally linked cases. All cases are basically linked to the Constitution because the Constitution is overarching. But this continued burden on the court to try and solve political disputes just adds to the burden and is most unfortunate. And I don't know what to do about it. It's out of our hands. It is really those who bring these cases to court to think whether they should burden the courts even further with cases that could be resolved elsewhere.
Also, absolutely.
Yeah.
So just moving to a slightly different topic, Judge. One of your recent judgments is the 2021 judgment of Chairperson of the Council of UNISA versus AfriForum. And this is a very important judgment because of its constitutional significance on language rights.
Yeah.
So I would love to hear from you what your view is on the role of these rights, language rights, over the past 30 years, and whether you think they should receive more attention in future.
I certainly do. It's not only language rights, but also cultural rights and religious rights. Those rights have tended to be neglected and stayed behind because they are not litigated that frequently. This was an exceptional because universities have ongoing challenges with getting their language policies right, and this was a language policy case. Now, the case was also of some personal importance to me because my first language is Afrikaans. I'm Afrikaans speaking. And there are a number of judgments, unfortunately, even of this court, that said that Afrikaans was the language of the oppressor. That's not correct. If you look at the history of Afrikaans, it was a language, a potpourri of languages that developed in the Cape, where you had the colonizers, the Dutch, where you had Malay slave mostly from the East, but also from East Africa. My forebears, I come from one of those Malay slaves, and also the other part of my forebears come from the Khoisan. So there you had the indigenous people, the Khoisan, you had the Malay slaves who were brought here for cheap labor, and you had the colonizers, the Dutch. And they had to trade, they had to socialize, they had to communicate, but mostly trade, because it's about economic survival for all. You had something that I need, and we would barter, but we need to barter in some other language. And so Afrikaans developed. What had happened was that the Afrikaners, white Afrikaners, had hijacked the language and just made it as if it was theirs. And that was the language that all of us, even those black Afrikaans speakers like me, were oppressed with under apartheid.
Imposed on everyone.
And so I had to set the record straight there. But most importantly, Afrikaans has had and as an Afrikaans speaker, I must concede that, readily concede it. Afrikaans and English had preferential positions occupied under apartheid because they were officially the only two languages, official languages under apartheid. And so the other languages, Setswana, isiXhosa, isiZulu, and all the other languages were grossly neglected. And it's still the case.
Yes.
And so we must find a way where we give recognition to those other languages and the language speakers of those languages to recognize their rights. The same with religions. I mean, under apartheid, it was the White Dutch Reformed Church. And so other languages must gain equal recognition, and the same with cultural rights. It can't be the culture just of one society. And so those rights have been grossly neglected, but it's also because they haven't really been litigated. But where the judgments that you do see from the courts do recognize those rights, language rights, cultural rights, and so on. There's the Palais case, the Nosering case. There are the language cases in the universities, and so on and so on. But it's important that they get their rightful place. And I'm sure that is something that will evolve and develop as people start asserting their rights.
Absolutely. Yeah. Okay, Judge, I would like to move to a few more personal questions about your career, if that's all right.
Yeah.
And you have emphasized in previous interviews and previous engagements that your career involved working with prominent South African activists and jurists, and I'm sure that was very exciting.
Yes.
And two of the prominent figures that you mentioned are Advocate Dula Oma and Chief Justice Arthur Chaskalson. And could you share your thoughts on how these figures shaped the democracy that we see today?
Yes. Yeah, I've been very fortunate. one could look at your background and your history in two ways. You could say I was most unfortunate that I had to grow up most of my life under apartheid. But on the other hand, you gain so much through that oppression. And so Arthur Shaskelson I didn't work that much with, but a lot with Dula Omar because we shared one floor. We were on the 5th floor at Huguenot Chambers, which was then the only advocates' chambers in Cape Town when I started. And of course I found Dollar there. He was considerably older than I because he was an attorney for a long time and then he came to the bar, became an advocate a few years ahead of me. But I also worked with others more closely, particularly former Chief Justice, the late Chief Justice Langa, and with people like Siraj Desai, who became a judge down there, also on the same floor as Dola and I, and people like Murumu Murane, who's still an eminent silk in KZN, and others. And it shaped my life not only as a lawyer, but also as a young South African. Because I come from, if you speak, relatively speaking, from a fairly privileged background in the sense that both my parents were teachers. My father eventually became a headmaster. And so we grew up in a house where even if you didn't get a bursary, they could still afford to send you to university. Cut a bit here and cut a bit there. Not live a luxury life, but you could go to university. I also grew up in a house where there was never really a shortage of food. There was never really a shortage of basic necessities like clothing and so on. Couldn't always get the toys that you wanted or the books that you wanted and so on. But it did shape my life to show what apartheid and oppression is doing to our people, the poorest of the poor. Because I wasn't one of them. I wasn't one of the poorest of the poor, but I could see from starting to do public interest law and human rights work with people like Dala Omar and others, what terrible suffering was occurring in the townships. It also acutely brought to the fore that apartheid was quite calculatingly sly about not only dividing black and white, but dividing blacks among themselves. So they create this hierarchy of those blacks that they would call colored, and those people who came from India, Indian descent. They would put them a bit higher than Africans, way below whites. And then so you create that apartheid even among blacks. And unfortunately that found fertile ground, especially among the so-called colored community. And when you look at the Western Cape, where I studied and where I practiced my law as an advocate. The Western Cape had influx control, so jobs were reserved for so-called colored people. The Western Cape had job reservation, influx control, and all the other things. So African people were deliberately kept out of the Western Cape. And so it came as no surprise when in the 1994 elections, the National Party then used the Swart Gevaar, the black danger, for their electioneering. And they warned people to say that if you vote for the ANC, then you would open up this province. You would take away influx control, take away job reservation, be free for all. They're going to take your jobs, they're going to marry your daughters, marry your sons, and so on.
Take over your lives.
And that found fertile ground, and many, many people voted for them. So it was bizarre that those who were oppressed, so-called colored people, voted for the oppressor because of this. And so these are all the things I learned as I engaged with them. They taught me law, but far more importantly, they taught me life. Life in its fullest, not just a segment of life and of society. And so that I grew as a young man, I grew as a lawyer, and I will forever be indebted to those giants that went before us.
Absolutely.
Yeah.
Amazing. So again, reflecting on the early stages of your career as well as the beginning of democracy in 1994, you mentioned, for example, how certain jobs were reserved for certain races. And I remember reading one of your biographies, and it said you had difficulty securing articles, for example.
Correct.
Right? So would you have envisioned that one day you would be sitting on the bench of the highest court?
Not in my wildest dreams,
South
no.
Africa.
You know, when I was growing up, we grew up in a house, Afrikaans speaking, but very Christian. Fixed norms, Christian norms. But also in a house where we were taught earlier, especially my father, non-racial. of his generation, he was one of the few. Remember, I grew up in the Northern Cape, so he's one of the few of his generation, and also a school principal, who risked his career by establishing SATU, South African Democratic Teachers Union, in that province, with a lot of younger generation educators, teachers at the time. And for that, he was refused promotion, even though he was well qualified. He had 2 degrees, like many other school principals didn't have, primary school principals. And he never got promotion because the apartheid regime and, as it was called then, the Department of Colored Affairs, held it against him. And so we were taught these non-racial values, and I saw it in action. So I wanted to become an attorney in Kimberley because Mr. Robert Sobukwe was the last black attorney in Kimberley. He was banished by the apartheid regime to Kimberley, and he practiced law there. And for many years after his death, many years, there were no black attorneys there, let alone the rest of the Northern Cape. Kimberley is the biggest center there. And so I thought our people need an attorney who could attend to their needs and help them. And I couldn't procure articles. One firm there invited me for articles and said, look, we want you, but the fellow who was here must pass his admission exams, otherwise we'll have to give him another chance. And with my luck, or bad luck, or good luck, turned out to be good luck, I think, he failed, and so there was no space for me. And so I went to the bar, which was a very risky thing to do, did my pupillage, became an advocate. And I must say that in February or March of that year, when I was doing my pupillage of the following year after I'd been didn't get articles, I saw the De Rebus, the Attorney's Journal, what they call their yellow pages, almost a third of the firms in Kimberley advertising for article clerks. And then I realized my color was wrong. But that turned out to be a blessing in disguise, because then I went to the bar and met up with people like Dalla, Omar, and Siraj Desai, later Johnny Dalanga and others. And we did a lot of this human rights law work. And later I started doing human rights law cases in the Eastern Cape and the rest of the country. And I met so many of those who had a lasting impression on my career. So I experienced apartheid firsthand, not only in my career, but also like all of us personally. Got chased off beaches, got chased out of movie houses, got chased off the buses, and so on. So yes.
Yeah, first-hand experience.
Yeah.
So speaking of, the people that shaped your career, you said once that you received a scholarship in the US to study your LLM, and Advocate Omar advised you to stay in South Africa.
Yeah.
Said South Africa needed young lawyers at the time.
Yeah.
What advice do you have now for young lawyers?
I was 24 years old at the time. I wasn't married. I didn't have a bond. I only had a car that I had to pay. I was getting more and more work. And so this Fulbright scholarship to one of the top Ivy League schools in the US comes along, Stanford, outside San Francisco. Wow. And I can't take it because Dalla gets me in the passage one day. As I'm coming out of motion court, I had to come past these chambers. He comes out, he says, what is this that I hear? You're leaving us to go to the US. And this was in 1985 for the first state of emergency. He said, you can't go. He said, we need young lawyers. We need all hands on deck. You can always go later. And later when I could go to Northwestern University in Chicago, by then I had a wife and a child and financial commitments, and I couldn't take it up. And so that is a regret that I have, that I should have done my studies then here locally part-time, but I just never got around to it. And so that's an opportunity missed, which I'll always forever regret. But in the bigger scheme of things, I think I did the right thing back then, to make that sacrifice, because then I got involved in a lot of cases, learned a lot. And my career progressed, as you've rightly said. I mean, I was admitted as an advocate at age 23, very young. I became a High Court judge at 39. I became a Supreme Court of Appeal judge at age 49. And I got appointed in this court at age 59. So things happened with the figure 9 at the end.
Progressively.
Progressively. But if you had told me as a young man growing up at university, even as an advocate, that I would one day be in this court, I would never have believed it. And yet here I am, and I feel incredibly blessed and privileged to be in this. It's a singular honor, and it's a privilege that I take very seriously, and I try to do my work the best I can. It sounds like I'm boasting, but I think if you'll ask my colleagues, they'll tell you that I work incredibly hard. I try to meet deadlines, and in a sense, my personal life is suffering because my wife complains. She says she's never ever seen me work like this. And there was a misconception for a very long time that the judges of the SCA work far harder than these judges. Until they get here. And then they realize there's no comparison. So it's an incredible blessing and a privilege, and I thank God for it. I do.
We thank God that you're here, Judge.
Thank you.
So would you then, I just back to the central question, would you advise, obviously the situation is much different now, we're living in a democracy, would you then advise the young lawyers to pursue their studies further?
Oh yes, I forgot about that.
Yes.
And the one thing I say to young law clerks or prospective law clerks when we interview them here, I say to them, without fail, all of them, you can ask those who have been here, how much I envy the fact that they have so many opportunities available. Back in the day when I finished my matric in 1978, the choice was stark. If you had the intellect and if your family didn't have you to go out and work, to start earning a living to supplement the income in the household, if they could afford for you to go and study, you'd either become a teacher, maybe a nurse, or do some or other skills training. So to do law was already a privilege. But these days the sky is the limit and beyond. I mean, people could really become astronauts if they wanted to, explore outer space.
Absolutely.
And I envy young people that. I will encourage young people. I always do my own, as I say, the candidates who I interview here. Study as much as you can. And if you can study beyond the shores of our country, do so, because it will enrich your life. I've been fortunate. I've been invited to Oxford twice now, in 2023 and 2022. And when you travel there to those kinds of institutions, you realize how big the world is, but also how much is available for us. And so young people who must grasp the opportunity. We also have scholarships available even through the Constitutional Court Trust at this court, so that people can study further. But not only in law, in all spheres of life, people must further their studies so that they can come back and plow back in our country, because our country needs skills. I must emphasize, we not only need skills, academic skills in areas like law and education and so on, but it's important that we also develop artisan skills. We need far more engineers than we need lawyers, and we need artisans, and we always need teachers, we always need nurses and doctors. So people must study, but they must remember that they owe some kind of duty to our country, to at least plow back so that we build a better future for all of us. And it's in our hands, especially the younger generation, you people. I mean, we're getting ready. We're in the last leg now, the last mile. So it's up to young people to make this a better country. There's just so much potential. Every time I travel, I realize what vast potential is in this country. And the biggest potential that we have is our people.
Absolutely.
No doubt about it. Yeah.
Thank you so much. So just as a concluding thought, I would just like to hear from you. What does the next 3 years of the Constitutional Court look like ideally?
Well, the court is going to grapple increasingly with socio-economic rights issues. I suspect and anticipate the court is also going to start grappling with land issues, because it's a burning issues. And I think the court is increasingly going to start under its general jurisdiction, which is another very challenging aspect of our life here at this court, the general jurisdiction issue, is that we'll increasingly start grappling with more complex issues like artificial intelligence. We're going to start battling with cryptocurrency issues. We're going to start grappling with cybercrime issues. More advanced spheres of life. As human beings expand their field of knowledge, they become more complex. The more the issues that come to the court are going to be more complex than merely constitutional issues. That's the first few courts I had to deal with. It's become a court with far more challenges. And not only this court, but also all other courts will start getting these issues. On the constitutional front, as I say, I think socio-economic rights, and I think land issues. I also think that issues that are related to civil and political rights will always be there. But as I see it, the biggest challenge for this court will be expanded general jurisdiction issues. That is really become very, very challenging because you have such a wide, diverse area of law where you really don't have specialists at the court. You need specialists in intellectual property law, you need specialists in tax law and shipping law, and commercial law generally, and that's what the court is lacking at the moment. And so the court is going to be increasingly challenged to fulfill its mandate, especially with this expanded general jurisdiction. That's how I see the court's challenges will be. Hopefully, 2 years' time, God willing, I'll be gone.
That is sad news for us, Judge, but good news for you and your wife.
You see, if you look at those photos there, my grandchildren and my children.
Yes.
I need to spend more time with them.
You have such a beautiful family, Judge. Judge, thank you so much for taking the time.
Thank you. It's been a privilege, and thank you for making time to come and interview. It is a landmark for us in South Africa, 30 years of democracy.
Yeah.
I think we've done well. When I travel around the world, I realize that we have problems in South Africa, but we're not the only ones. Countries with far more advanced economies and far older constitutions than ours have serious challenges. I mean, you just need to look at the US. Even a thriving democracy like Canada, where I visited in June, July for a conference, have their own challenges. How to address the needs, the culture, we spoke about culture, the language rights, and the constitutional rights of the First Peoples. First Peoples, the Inuit, and other First Peoples there. It's increasingly becoming a challenge there. Country like New Zealand, same, the Maori and the First People there. So yes, we have challenges, but we live in a wonderful country, and I think we've come a long way in 30 years.
Absolutely.
People moan and groan, and I always think of the Israelites when they were yearning to go back to the flesh pots of Egypt, without realizing what they are yearning for. We often forget the good, positive things when things become really bad in a country. But when I look back 30 years, I'd 1,000, 1,000,000 times rather be here than back where we were 30 years ago.
And it's also interesting from an outsider perspective when you go to other countries, how other people speak so highly of our constitution.
Absolutely.
And how other courts reference the decisions of this court.
Absolutely. And none more so than Canada. As you know, our constitution, specifically the Bill of Rights, is modeled on Canada's Charter of Fundamental Rights. And they cite our cases all the time, and we cite theirs. But when I was there, I met with some Supreme Court justices. Some of them have become my friends over the years, one or two of them that I know. And they all wax lyrical about the Constitution, also about the jurisprudence that this court has produced and continue to produce. So South Africa is held in very high regard, and I think we are more skeptical and cynical and critical ourselves inside the country than those outside. A lot of people admire what we have achieved. Even the recent elections and the outcome and where we are now. Many countries say, well, it's amazing that they were able to do that. Basically, a bloodless changed. It was a bloodless revolution, bloodless coup, where a party in power for so long willingly relinquishes the reins of power and say, let's share power. It's unprecedented. Even in the Western world. We're supposed to be so far advanced than us. And so, yes, I think we've got much to celebrate with this 30 years. And there's a lot of work to be done.
Absolutely.
But we mustn't forget our blessings, and we mustn't underestimate what we've achieved. Thank you.
I think we can close on that note. Thank you so much.
Thanks very much. It was less painful than I thought it would be.
I'm happy to hear that.
Thank you.